There's no question. The judge wants to have it both ways. He says that the question of whether or not there was a violation of campaign contribution law, which there wasn't, is a question of fact, and then he denies the defendant the right to disprove that fact and essentially puts the burden of proof on the defendant. This hasn't been widely noticed, but under New York law, the prosecution does not have the burden of proof when it comes to closing argument. The defense goes first. Now, what's the defense supposed to do? The defense under the Constitution doesn't have to prove anything. It doesn't have to assert anything. It has no burden of going forward, no burden of proof. But when you tell the defense that it must go first, the implication to the jury is that the defense must disprove the case without even knowing what it is. And then you have these two gaping holes in the prosecution's case. The prosecutor misled the jury by saying that Cohn's testimony is corroborated. There are 2 points in Cohn's testimony that are crucial. Number one, the meeting in which he and Weisenberg allegedly concocted this plot, no corroboration for that. And where's Weisenberg? He hasn't been called. And second, the phone call where there was a complaint about some 14-year-old kid harassing Cohen. There is a witness to that. And I hope the judge will give a missing witness instruction. There wasn't enough emphasis on that by the defense, in my view. But the judge should instruct the jury, ladies and gentlemen of the jury, the burden is on the prosecution. They must prove that at one or both of those meetings, there was a plot. And there's no corroboration for that. It's all dependent on Cohn's testimony. And there are 2 witnesses that could testify, but the prosecution didn't call them. You should infer from the fact that the prosecution could have immunized the witnesses, could have called them, but didn't, that if they had called them, the testimony would be unfavorable to the prosecution. If the judge fails to give that instruction, it's clearly reversible error, 1 of 10 or 15. I don't think I've ever seen as much reversible error in a case as I've seen here, but they don't care because they want the conviction down and dirty before the election, and then if it's reversed on appeal after the election, nobody cares. And of course, the appeal goes to a New York court as well. So this is so unfair. It is such a stain on the American system of justice. You know, as a liberal Democrat who's voted all my life for Democrats, don't know who I'm going to vote for in this coming election. That's an open issue. But in the past, I voted Democrat. As a Democrat, I'm appalled at the way the law has been manipulated and distorted in order to get Trump.
All right.
Trump.
Exit question.